Yes, Mr.
My lords, my lady, good morning. I appear for Mr. Augustine. The letter from Mr. Mountford appears for Data Cars, who you may have seen were not represented below. You ought to have a core bundle and a short supplementary bundle, which, if they're in hard copy, should be in the same folder. Bundle authorities, a couple of separate documents which were emailed yesterday to authorities, which we can perhaps deal with when we get there, if that doesn't ring any bells with your lordships.
Yes. No, it does. There was the promise of a hard copy of, certainly, of the Ahmed case.
Yes, and I can hand that up now, my lord.
Thank you. Or when you get to it.
When we get to it, yes. Also separate is my learned friend's skeleton argument, which was filed separately and late because he and his solicitors, in fact, were instructed pro bono late in the day. We, of course, take no objection whatsoever to that.
Well, we are particularly grateful to both of you by different routes for appearing. It is for the public good,
yes,
that we sort this point out.
My lord, a few words by way of introduction and background facts. Mr. Augustine, as you know, was employed as a driver by the respondent. Part of the arrangement was that he would pay what was called a circuit fee of £148 per week to access its booking dispatch systems. I would just interject that it's obviously quite unusual for an employee to pay an employer a fee, and what was in fact going on at the time was that they were proceeding on the premise that he was self-employed, and it was a later judgment of the tribunal, which we don't need to go to, but which held that he was in fact employed. So he was paying a circuit fee. He brought a claim which alleged, among other things, that that flat fee, which was applied to all drivers, regardless of how many hours they worked per week, was discrimination contrary to Regulation 5 of the part-time workers regulations. He worked an average of 34.8 hours per week. And it isn't in dispute that he was a part-time worker for the purposes of the regulations. Under those regulations, it depends on the custom and practice of the enterprise, as I will show you when we come to the regulations. So he was part-time, that's not in dispute. Under the regulations, a part-time worker needs to select a real comparator to bring a claim of discrimination on grounds of part-time status. He chose a comparator who worked an average of over 90 hours per week. And again, it is not in dispute that that person was a full-time worker and that Mr. Augustine was entitled to choose him as the comparator.
It's a rather extreme comparator, but as I understand it, that doesn't matter. I mean, if he picked somebody who worked an average of 65 or 70 hours a week, it would be just as good, wouldn't it?
It would be just as good.
Yes.
It could matter to remedy. I'm going to come on to that, because there could be a question at the back of my lord's mind, which is a remedy-focused question. But I'll come back to that if I may in due course.
Yes.
It doesn't matter, though, for the purpose of the analysis of whether there's direct discrimination. The next question for the tribunal was whether the claimant was treated less favourably than the comparator. And you'll have seen that the Employment Tribunal held he was not, in essence because they thought everyone was treated in the same way, everyone had to pay the same fee. And the EAT overturned that finding, and it's now not in dispute that he was treated less favourably than the comparator. It is important to have in mind for the next step of the analysis what that less favourable treatment was. And the less favourable treatment was the fact that he paid a higher circuit fee than his comparator when looked at in proportion to the hours worked. And that, as the EAT accepted, is the right way to assess less favourable treatment in part-time worker contexts, because it applies what is called the pro rata principle. So he was paying a higher circuit fee per hour worked. That then brings us to the next stage of the analysis, which is why we're here today, which is whether that less favourable treatment was on the ground that he was a part-time worker. And going to the heart of it, my very simple submission is that the answer to that question is straightforward. If you ask why was he paying a higher fee per hour worked than his comparator, the obvious and straightforward answer is that it was because he was working fewer hours than his comparator. And it is therefore inherent in the treatment in this case. It's inherent in applying a fixed fee to all workers that it will treat part-time workers less favourably than full-time workers. It doesn't matter that there is no intention to discriminate, or that the motivation might be, as in this case, for something very different, which was to run the business in a particular way. Those are points which could be relevant to justification, later stage of the analysis, but they're not relevant to the question of whether there is discrimination. And that intention point is where the Employment Tribunal went wrong, because the Employment Tribunal thought it had to consider intention. The EAT agreed with my submission that the Employment Tribunal erred in that regard also. It did not need to consider intention.
Yeah, may I just ask you a question,
Yes.
please, Mr. Jones? If that analysis is correct, would it be the same whichever of the two rival tests for causation is the correct test?
My lady, I'm going to hesitate before answering that because the two rival tests have been described in different ways in different cases. So I want to be clear which rival test we have. Maybe I could express it this way.
Yeah.
The authorities, some of the authorities that we're going to look to, which predate JFS, proceed on the premise that there are two genuinely rival tests. One is sometimes called the but-for test, and one is called the reason why test. And what I'm going to show you by reference to JFS is that that's the wrong way of looking at it, and that there is in fact just one overarching test, which is the reason why. Now, under that penumbra, there are two possible routes. One is the inherent route, or what is sometimes called the criterion cases. And I would say this is an inherent case or a criteria case.
Yeah.
The second is what you might call the subjective motivation cases.
Yeah.
And those are cases where it's not inherent in the treatment, but actually the discriminator was subjectively influenced by the person's race, sex, part.
But this isn't really a case that's about
but
motivation, is it?
This doesn't really fall into that category.
Yeah.
So one could ask that question. One could ask, well, were they intending to discriminate against a part-time worker? And the reason why it's possible in some of these cases to ask that is the answer might not be that they had an animus towards a part-time worker, but it might be they were, for example, trying to take advantage of part-time workers or exploit part-time workers. So you can see that it could, in theory, come up in some of these cases. But that's not the case here. It's not what we're arguing here. Here we just say it's inherent in the treatment.
Yeah. So if it is inherent in the treatment, it doesn't matter whether the fact of being a part-time worker is the sole cause of the treatment, or the fact that he's a part-time worker is the sole cause, or any other cause of the treatment.
That's right, my lady.
Sorry, I'm not putting that very articulately.
Well, no, but my lady's anticipated my next point, because I started a moment ago by saying it doesn't matter that there was no intention to discriminate, and the EAT agreed with me on that.
Yeah.
But I also say it does not matter that there could be other contributory causes. And this is where the battleground lies in this case. Because the point that the EAT makes is that because the flat fee applies across the board, you're able to point to what I said is inherently discriminatory treatment. In other words, differences between part-time workers and full-time workers. And you'll always find that. If you pick any part-time worker and any full-time worker, there will be a difference because of part-time status. But you could also say there are differences between full-time workers. So the full-time worker who works 45 hours a week is also going to be paying a higher circuit fee on a per-hour basis than a full-time worker who works 90 hours per week. So that is why this is a case, or can be seen as a case, of multiple causes, because it's a case where I have to accept the less favourable treatment which Mr. Augustine complains about is partly caused by his part-time status.
Yeah.
And one could find a point if one could identify precisely when a person is full-time. I think the EAT suggests it's the average hours worked in this workplace, I think they say it's 43.5 hours, is how they've understood the tribunal's judgment. In fact, I think the tribunal doesn't identify the cut-off point, but theoretically one could identify the cut-off point and say people working below that will be treated less favourably than that person on grounds of part-time status. But when you start comparing them to full-time workers who worked longer, there are different causal factors at play.
Yeah, no, that's very helpful actually. So in fact it might matter which is the correct test on these facts.
It doesn't matter in the sense that it is the inherent test is satisfied because it is inherent that it will discriminate against part-time. But whether or not they intend to discriminate, it's not territory which we've raised. We haven't said that they've intended subjectively to discriminate in this case.
No.
In brief, my submission is that it is not lawful to discriminate against a part-time worker in part because they're part-time, or to put it another way, because they're part-time combined with some other factor. And I say that that's contrary to the directive, and even if that were wrong, it's clearly contrary to the regulations. And as you will have seen, the EAT agreed also with me on that, but the EAT considered that they were bound to follow the approach of the inner house in McMenemy.
Yeah.
So in due course, I'm going to need to show you that there are compelling reasons to not to follow the decision of the inner house in McMenemy, for which the minimum threshold, according to the Janjuk case, my lady will remember well, is that it is clearly wrong. So compelling reasons for which the minimum threshold is that it is clearly wrong. Can I make an observation just on Janjuk very briefly from the outset, because it's a practical observation that my lords may want to have in mind, which is we are currently awaiting judgment from the Supreme Court in Janjuk. And it did occur to me, and I mentioned it to my learned friend, that your lordships may feel in the circumstances, and possibly depending where you get to in your thinking about the case, that it might just be in the interests of efficient resolution of this case to wait until the Supreme Court's judgment comes down, at which point we might potentially make more representations on the papers. I just mentioned that.
Does anybody know, was it actively argued before the Supreme Court that they should pronounce on the attitude this court should take? So they might say, well, we're not interested in Abbott and Philbin and all that. We're not. There's clearly no binding previous decision of the House of Lords or the Supreme Court, so we can just decide the point on its merits and the answer is X.
Yes, they might do that. My understanding is that the point was argued, but I entirely accept that the Supreme Court does not itself need to resolve that question.
I mean, in Abbott and Philbin, which I'm sure you're going to show us, but the House of Lords, they didn't make pronouncements on precedents. They decided the point, and they said that the Court of Appeal had been right to follow the. It was the Court of Session there, wasn't it?
Yes.
But they sort of obviously rightly, Court of Appeal. That was all they said on the subject.
That's right.
The trouble with the Supreme Court is they sometimes take 6 months. They sometimes take a year.
Yes.
You may not want to wait that long.
No. Well, my lord, I put it out there.
All right. Well, anyway, we'll think of you're not asking us to.
I'm not asking
to
you
adjourn.
Oh, I certainly not.
It's too late now, but Did anybody think about applying EAT level for a leapfrog certificate, so you could have dispensed with us altogether? It used not to be available in tribunals, but it is now.
Well, my lord, the answer to that is I did not, and on that basis, I think I can confidently say nobody did.
All right.
But yes, perhaps that would have been the solution in this case. Against that background, this is the course I propose to take. I'm going to look at the directives and the directive and the regulations first. Secondly, I'll come to the authorities. Thirdly, the EAT decision in this case. And lastly, I will come back to the threshold and the Janjuk question. So starting then with the directive, it starts in the authorities bundle at page 443, which is, I'm afraid that's a bundle in several parts, and it's in part 2, tab 2. You'll see on page 443, it's a directive concerning the framework agreement, because the way that this directive works is that it appends a framework agreement that we'll go to in a moment, and essentially requires the member states to bring into effect laws to give effect to the framework agreement. But starting with the words of the directive itself, on 443, you see at recital 11, the signatory parties wish to conclude a framework agreement on part-time work, setting out the general principles and minimum requirements for part-time working. And there are other references to this directive setting the minimum requirements. It's a minimum harmonisation directive. And further on in that recital, you see the two broad purposes of this legislation, whereas they've demonstrated their desire to establish a general framework for eliminating discrimination. That's the first general purpose against part-time workers, and to contribute to developing the potential for part-time work on a basis which is acceptable for employers and workers alike. Recital 16 on that page leaves it to member states to interpret provisions if they're not interpreted in the directive itself. The framework starts from page 446. And in the preamble, you'll see the second paragraph there, again emphasising minimum requirements. Over the page at clause 1, we have the purpose, and there again you see the two purposes which I've essentially already read out. The first one being the removal of discrimination against part-time workers. And then the key provision for our purposes is clause 4, principle of non-discrimination. In respect of employment conditions, part-time workers shall not be treated in a less favourable manner than comparable full-time workers solely because they work part-time, unless different treatment is justified on objective grounds. And then where appropriate, the principle of pro rata temporis shall apply. Now, you'll see there that it doesn't actually use the same wording as the regulation, so it doesn't use the language of on the ground of, it says because. So the language is put differently in UK legislation. But of course it says solely because, and the question is what is meant by the word solely. I'm going to come to an authority in a moment, but my broad submission to you is that there is not much assistance at all to be gained from any of the European authorities on this particular question. The most forceful point in my favour, just looking at the directive, is a point which is made in several of the EAT authorities, which we will come to, which is that it would be extremely difficult to reconcile a directive whose purpose is the removal of discrimination against part-time workers with a scheme which permitted discrimination partly on the basis of part-time status. an example which is given a couple of times in the authorities is, what if an employer chose to pay a lower rate to part-time workers in a particular factory, so that there are two effective causes. You've got to be in a particular factory and part-time. That would be a classic example of a case with two causes, and it is impossible to see why the European Parliament would have wanted that to be treated as lawful. Now, Mr. Mountford has pointed out in his skeleton argument that the example which I've just given you, and which crops up in some of the cases, is imperfect. It's imperfect because if you look at clause 3, definitions, and you look at the definition of comparable full-time worker, you'll see that it, generally speaking, means a full-time worker in the same establishment. And then there's a subparagraph underneath which allows for one to depart from that. But Mr. Mountford's broad point is, in the example which I've just given you, ordinarily the worker would need to compare themselves to a worker in the same establishment, and on that basis, I think Mr. Mountford would say, the discriminatory treatment would only have one cause as between those two individuals. That would be the part-time status of the part-time worker. So that is a fair criticism of that particular example, but one can make precisely the same point by just tweaking the example, and one could think of a large number of possible ways of doing that, but for example, discriminating against part-time workers who started after a particular date, or discriminating against part-time workers who work on particular days of the week. We will see other examples in the cases.
But so what's your answer to Mr. Mountford's broad point, which is that this directive didn't originate in proposals by the European legislature, if one can use that loose term, but originated in a negotiation between employers' organisations and employees' organisations, and that may well be what they were prepared to agree.
Well, all legislation from the European Parliament results in one way or another from a process of negotiation, and it's certainly true, I have to accept, that in this context, that involved balancing the promotion of part-time work and achieving something which is, as it's put in recital 11, which I read out, acceptable for employers. Yeah. So I entirely accept that there is a balance being struck in this legislation. There is, however, nothing to suggest in the materials which Mr. Mountford's put forwards, which my lady is referring to, that the word solely was included to achieve that particular purpose. And when one looks at the purpose of removing discrimination, which is what I'm focusing on, there is nothing here to suggest that there had been, as it were, a deal done between employers' interest and employees' interest.
Well, we don't know.
On the meaning of
it was presumably all done behind closed doors, and there wouldn't be a record of it. But why is the word solely there?
Well, I say that it's emphasising that we're concerned with less favourable treatment because of part-time status rather than for any independent reason. So it isn't there to suggest that if there's less favourable treatment in part due to part-time status, then that is acceptable. There's one case which I ought to take you to regarding the directive, if I may. It's the case of Whipple, which is in the authorities bundle at tab 5, page 87. And I should say at once that this case is of, at best, tangential relevance, but I'm going to it because it's referred to in a couple of the later cases. And so one needs to understand what's being said in this case to understand some of the later cases that I'm going to go into. Ms. Whipple was a part-time worker who had what is called in the case a work on demand and as you please contract, which is, as I understand it, what we would know as a 0 hours contract. So she had a 0 hours contract, and she compared herself to a full-time worker, and she argued that she had suffered less favourable treatment by not having guaranteed hours, and she argued that she ought to be compensated by reference to the difference between the amount of money she did earn and the amount of money she would have earned had her employer required her to work the maximum number of hours that it could have required her to work. Quite an ambitious claim.
Yes.
Now, the relevant question for our purposes is on page 102. The question which was referred, you'll see it's incredibly broadly expressed, and it's actually referring to directives on sex discrimination as well as Clause 4 of the Framework Agreement. And as I say, it's very broad, and I just must Clause 4 of the Framework Agreement on part-time work be construed as meaning that there is no objectively justified unequal treatment if, in the case of part-time workers, of whom the vast majority may be assumed to be women, an employer expressly rules out an agreement on hours of work and the extent of working time, whereas in the case of full-time workers who are not predominantly women, the extent and in part the allocation of working time are already provided for. It's a very broad question. And the answer to that question one finds from page 111. The question is, again, set out in 52. At 54, which you'll see has been sidelined, the court says this. In that regard, first, as has already been pointed out in paragraph 42, clause 4 of the Framework Agreement.
So sorry.
I'm
Did you
sorry.
say 52?
54 is where I'm reading.
54, sorry.
54.
I thought, yeah, got it.
So as has been pointed out, clause 4 precludes part-time workers from being treated less favourably than comparable full-time workers on the sole ground that they work part-time unless different treatment is warranted on objective grounds. There's then a bit of a diversion into comments on the Sex Discrimination Directive. And if we then pick it up at 57, you'll see that the question, coming back to clause 4, the question which the court asks itself is whether Miss Whipple is treated less favourably than a full-time worker in a situation comparable to hers. And the answer which the court gives to that question is no, because the full-time worker is not comparable. And in broad terms, the reason why the full-time worker is not in a comparable position is, one sees it in 61 and then the conclusion in 62, because the full-time worker is on a contract with set hours and she is not on a contract with set hours. Now, my lords, you may be wondering what is the relevance of this. There are 2 points. The first point is, this reasoning about comparability is, on one view, rather restrictive and more restrictive than the approach which the House of Lords adopted subsequently to the same question. And in that context, Baroness Hale makes some comments about how the regulations can go wider than the directive. So it's a somewhat long-winded route to get me to that point. I'm going to show you that when I come to the House of Lords case of Matthews in due course. That's one reason we need to just have Whipple in mind. The second reason, though, is that paragraph 54, which has been sidelined, is referred to by my learned friend, and it's referred to by the Inner House in McMenemy, because of the way that clause 4 is described there on the sole ground that, which is not the precise language of clause 4, which is solely because. And as I apprehend it, what is being said is, on the sole ground tends to reinforce the view that it has to be, as it were, the only the only possible reason for the treatment, and it rules out multiple causes. That's as I understand the reliance, which is placed on para 54. And so I took you through these paragraphs also to show you that 54 is nothing more than a background description of clause 4. This is not a case about grounds or sole grounds or anything like that. It's a case about comparability, and that's the way it's decided. So one cannot get anything from the particular form of words which is used in paragraph 54. My lords, with that diversion out of the way, if I may, I'd like to go next to the regulations, which are, again, in section 2 of the authorities manual, tab 1, which starts from page 411. They are made under Section 19 of the Employment Relations Act 1999. That was one of the documents which was circulated yesterday, which I do have in hard copy here, if it would assist for me to hand it up. I want to show you that very briefly, if I may.
Section 19.
Section 19.
I have that.
Yes, I've got that. Thank you very much.
Yes, we've all got it. Thanks.
If one looks across at section 19, one sees I apologise, I had thought there was a reference in this section to the directive which I was going to draw to your attention, but if there is, my eyes are not showing it clearly.
No, not in section 19.
Not in 19. The only point then that one gets is that it's a general enabling power for the purposes of securing that persons in part-time employment are treated for such purposes and to such extent as the regulations may specify, no less favourably than persons in full-time employment. Back in the regulations, on page 412, there are some definitions, and that's where we don't need to go into the pro rata principle for today's purposes, but just for your note, that's where the pro rata principle is defined. On page 413, you get the definitions of full-time and part-time and comparable full-time worker. The key provision for our purposes is Regulation 5 on page 417. A part-time worker has the right not to be treated by his employer less favourably than the employer treats a comparable full-time worker. But then at 2, the right conferred by paragraph 1 applies only if the treatment is on the ground that the worker is a part-time worker and the treatment is not justified on objective grounds.
I haven't really read very much around sort of in the authorities, but from what I've read, nobody seems to focus on the phrase "only if." So does that have any significance or not?
Well, it clearly, first of all, Edis is right, as far as I'm aware, that also hasn't been discussed in the authorities. But secondly, it clearly one can only bring a claim if, as it were, the treatment is on the ground, that the worker's part-time. That's a threshold requirement to be able to bring a claim. But that's different from saying, and if you do bring a claim, it must be only on the ground that the person was part-time, or that the less favourable treatment was not contributed to by other factors.
Because there's some criticism of the inner house in McMenemy for accepting an agreement by the parties that the regulations were intended to give effect to the directive. I was just wondering whether that agreement was based on the presence of that phrase in Regulation 5.2, and that's why they didn't argue about it. It's just a question that occurred to me when I was reading the authority.
Yes. Well, but I think the point which comes out of that, whatever the reason for the concession was, it wasn't argued and it was conceded, whereas in some of the later cases, hasn't been conceded, not conceded here.
No, I understand that, but it just seems odd to me that no one's really thought about whether those words mean anything.
Well, my lady, they do mean something, because if one takes two workers, one of whom is part-time and one of whom is full-time,
Yeah.
there may be all sorts of reasons for the different treatment between them. And I mean, in fact, McMenemy is an example of that.
Yeah.
So many different reasons for the difference in treatment between them. Now, some of those reasons would be, as it were, filtered out at the comparability stage.
Yeah.
Because if it turns out, for example, that they're doing different work, then what you would find is that they're not comparable.
Yeah.
But some of those reasons won't be filtered out, as I've put it, at that stage. And so you'd be left with a situation where there is less favourable treatment between the two. And one has then to say, we're only concerned with the less favourable treatment if it's on the grounds of the part-time status.
Yeah.
Now, it might be on the grounds of part-time status and other things, but if it's not on grounds of part-time status at all, then the case just fails at that hurdle. So that's what those words "only if" are achieving. And we'll come to McMenemy, but the result in McMenemy is right, and this is the submission I made at the EAT. They get to the right place, but through the wrong route. And so that's why I mentioned McMenemy a moment ago. It's an example of a case where there's a difference in treatment between the full-time comparator, who got payment because they, in lieu of when they worked on Monday bank holidays, and the part-time worker. But that just wasn't on ground of part-time status.
No.
So I'll look at that in more detail later, but that's what those words "applies only" are achieving. They're making clear that that's the ground that one needs to focus on. I've mentioned justification on objective grounds, just to be clear, your lordships will have in mind that it's very unusual to have a form of direct discrimination which can be justified on objective grounds. One can see why one would have it here, because there may well be justifications for treating part-time workers differently, very different to racial discrimination, etc. But that is an unusual provision. The pro rata principle.
It's not unique,
though. It's not unique. I think one sees it in the fixed-term workers context. So, no, it's not unique. I should show you on page 420 the right to complain to an employment tribunal. And then on the facing page at subparagraph 7, the right to compensation. And then at 9, the requirement that the compensation shall be such as the tribunal considers just and equitable in the circumstances. And I'm highlighting this because of the point my Lord made to me at the outset, which is that Mr. Augustine has compared himself, as he is entitled to do, to the full-time worker who, in fact, works the most hours. So one gets this in equal pay claims, where the claimants are able to get information about normally the men they want to compare themselves to, and they're entitled to compare themselves to the best paid male comparator. So he's entitled to choose his comparator, but I'm not saying that it follows that the compensation that he will receive at the end of this should necessarily be premised on the hours that that comparator was working and the pro rata fee that that comparator was paying. There is clearly scope for the tribunal to make an adjustment to reflect the fact that there is more than one operative cause in this case. To be clear, I'm not making, as it were, a formal concession about what the remedy should be. We're not arguing about compensation today, but I do just highlight that there is that power in the tribunal to make sure that compensation is just and equitable. I'm moving now to what I call the third part of my submissions and the authorities, the English authorities. I want to start with an authority regarding the scope of the regulations. That's the Matthews case I've already mentioned. It's in the authorities bundle, tab 6, starting from page 118. You will see from the head note that the retained firefighters were arguing discrimination under the 2000 regulations by comparison with full-time firefighters because the part-time firefighters were excluded from the pension scheme and various other forms of treatment that they said was less favourable. One of the issues which arose in the case was whether the part-time firefighters were on the same type of contract as the full-time firefighters, which is a necessary condition under the regulations for comparison purposes. If you turn forward to page 125, you will see Baroness Hale, paragraph 24, refers to the regulations having been made under section 19 of the Employment Relations Act. And she says, without prejudice to that general objective, the regulations were also to comply with the United Kingdom's obligations under Council Directive 97/81. Just pausing there. That was what I was struggling to remember earlier on. I'm going to need to circle back to this. I'll have a look over lunch to see if I can find the provision. But there is a provision that makes clear that the regulations have that general purpose and without prejudice to that general purpose are to implement the requirements under the directives. That's the point that Baroness Hale is making there. So that's, she makes that point. And if one then turns forwards to page 130, please. What has happened in the intervening paragraphs is that Baroness Hale has looked at the regulations and decided that the retained firefighters are comparable to the full-time firefighters. And at paragraph 37, picking it up partway through, she says at C, nor am I unduly troubled by the decision of the European Court of Justice in Whipple.
You used the adjective ambitious and she used the adjective outrageous.
Outrageous. Now, she's not, to be clear, I don't want to put this too high. Baroness Hale is not saying that Whipple is necessarily contrary to her own analysis. Her analysis proceeds on the basis of the regulations. She then turns to Whipple, which is quite restrictive in the way that I described when we went through it. But Baroness Hale is simply dismissive of it. It was an outrageous claim, but then at D, furthermore, the court was concerned with an employment relationship under clause 3.2 of the framework agreement, whereas we are concerned with the express words of the 2000 regulations. The regulations should be read as going at least as far as the framework agreement goes, but it's open to them to go further, as is clear from the broader regulation-making power contained in section 19 of the 1999 Act. Lord Nichols agreed with Baroness Hale. He says that at paragraph 1, and Lord Hope gave a concurring judgment, but at paragraph 12 also made clear that he agreed with Baroness Hale. I rely on this in support of my argument that the regulations could go further than the directive.
What do you say about Mr. Mountford's point, which is that they had to go further if they wanted pay to be included in the matters about which complaint could be made?
I apologise.
Yeah, sorry, that wasn't a clear question. I think Mr. Mountford is suggesting that the reason the Section 19 power was enacted in the terms in which it was because the framework agreement and the directive that annexed it were made under the social chapter, so they couldn't cover pay, and so a broader power needed to be taken so as to cover differences in pay.
Well, that is not the respect in which Matthews is drawing a distinction with the directive. So the question in Matthews doesn't in any way relate to pay. It relates to the way in which you compare the types of contract that different workers are under. And there are, the directive, of course, has to have a basis for drawing that comparison. And the broad overview is that in Whipple, the court, as I said, takes rather a restrictive view. The reason it's restrictive is that, as you remember, what happens in Whipple is the court says, well, they're not on the same type of contract because the part-time workers have a 0 hours contract, whereas the full-time workers have an entitlement, in fact, an obligation, they say, to work certain hours. And just pausing there, that's the very thing that the part-time workers were complaining about. Mm-hmm. So it is rather a restrictive approach to comparability to say that if the very clause that you're complaining about, to say that that very clause can be relied on to defeat comparability. Now, that's the reasoning that Baroness Hale has in mind when she's saying she's not concerned by Whipple, because the shape of the arguments in Matthews is, maybe one needs to go back. If one looks at paragraph 28, there is a somewhat ambiguous paragraph in the regulations that says, for the purposes of paragraphs 1, 2 and 4, the following should be regarded as being employed under different types of contract. A, employees employed under a contract that is neither for a fixed term nor a contract of apprenticeship. B, employees employed under a contract for a fixed term that is not a contract of apprenticeship. And so it goes on, and it's not clear precisely what's being said here. Is it being said that you have to have workers in different categories in order to compare them? Or is it being said that they have to be in the same category to compare them? And the end result of the analysis is that they have to be in the same category. So if you have 2 employees who fall into category A, then they can be compared. And if you have 2 that fall into category B, that they can be compared, and so on. But one doesn't go as far as the court in Whipple went in drawing a distinction based on, as in that case, the number of hours which were being worked or which were guaranteed. So, my lady, it's a long-winded answer to your question, but the point in Matthews is that the regulations can go further than the directive in a context which is not about pay.
Yes, it's not sort of made 100% clear that that's the reason, but you say that's what's going on.
Yes.
There are authorities in other areas of law. I'm thinking of health and safety at work, where there are directives, where it's common to find domestic legislation affording more protection than is required in the directive. And there's quite a lot of authority saying that's perfectly all right. Why would that be objectionable?
Yes, my lord, yes, and I used the shorthand when we looked at the directive of minimum harmonisation, because of course there are, on the other hand, maximum harmonisation directives. This is not one of those. This is one which on its face says it's setting minimum requirements. Next, under the broad heading of authorities, I want to look at the authorities dealing with on the ground that, or similar such expressions, in contexts other than part-time working. and I'm going to come to the JFS case, which we've already had a bit of a discussion about. It's in the bundle starting from tab 10, page 183. And here, my lords, forgive me if I repeat some of what I said at the outset when we were discussing JFS, but I'll just go back through it to touch on the main points and maybe fill in some of what I said earlier. Pre-JFS, there were what were sometimes thought of as two different streams of authority on the test for direct discrimination. There were firstly cases such as James and Eastleigh Borough Council, which was a case in which the council had decided that those of pensionable age could swim free of charge, and in which the House of Lords held that that was direct discrimination because it meant that men between the ages of 60 and 65 had to pay, whereas women did not. And in that case and other similar cases, the House of Lords used the expression "but for" to illustrate the point, because one can say in that case, well, but for being a man, I wouldn't have had to pay to swim. So that was one stream of authority. Secondly, there were cases, also House of Lords, like Nagarajan and Khan, where the conduct is something quite different. Conduct is something like not promoting someone, not giving someone a job reference. And in that context, in order to understand why, the reason why they were subject to that treatment, it was said to be necessary to look at the alleged discriminator's subjective thinking. And those two streams of authorities gave rise in the lower courts to several types of misapprehension, some of which we're going to come on to. But broadly, that there was a conflict between the authorities, and in some of the authorities it suggested that the test is unclear. Does one have to apply a but-for test, or does one have to look at the reason why and subjective motivations? And as I said at the outset, JFS clears that up, because the question is always, what was the reason why the person was treated less favourably? And against that general starting point, there will be a category of cases where the treatment will be inherently discriminatory, and James is an example of that. And I just pause on James to emphasise, in order for treatment to be inherently discriminatory, it doesn't have to say so on the tin. So the policy in James was people of pensionable age swim free. It wasn't, in lights, women of these ages swim free and men have to pay. But the point is that using pensionable age as a filter, when that varies according to sex, will be inherently discriminatory. And in that category of case, because
pensionable age is a proxy for sex.
Because it's a proxy.
Yeah.
And in that, yes, but I'd add this, not to overcomplicate it, but it's a proxy for sex in a particular age group, which I just mentioned in passing because, of course, there's actually more than one operative cause on that age group as well. True. Yeah. But in this particular category, it is not relevant to look at the subjective intent or motivations. There is then a second category, such as the promotion case or the reference case, where there's nothing inherent in the conduct, there's nothing inherent in not promoting someone and not giving them a reference, which is discriminatory. But one needs to look at the mental processes to work out whether race or sex or whatever it is made a difference to the decision. Now, coming to JFS itself, there are 5 speeches for the majority, and I'm going to, and this is a very well-known case, so I will deal with this very quickly and give you references, but I will take you to a couple of important points. I'm going to start with Lord Mance, in part because Lord Clark agrees with Lord Mance, and so in a sense this one has the imprimatur of both, which is not so true of the others. If we go to page 220, and I would just pause and invite you to read to yourselves paragraph 78, because it essentially makes the points which I've just been making. I'll just give you the references, if I may, to the others. Lord Kerr, at paragraphs 113 and 114.
Sorry, Mr. Mayor. We're starting with the majority.
Well,
is there a majority?
Well, there is a majority in the sense that the 5 which I'm going to give you will say essentially the same thing.
Right.
They say essentially the same thing. I wasn't going to give you the references to the minority. In fact, I have those written down in my chamber so I can get them if that would assist. But
5 will be quite enough.
I was just going to give you the references to Lord Kerr at paragraphs 113 and 14.
Yes.
Lord Phillips at 13 to 23. And Baroness Hale at 58 to 65. And I started with Lord Mance and said Lord Clark agrees. I don't have the reference to Lord Clark, but I think it's maybe a single paragraph. That could maybe go on my list for lunch if my lords would like the reference to Lord Clark. But I think he simply says he agrees with Lord Mance. Now, of course, this approach can mean that there may be cases where there is discrimination for the purest of reasons, if I can put it that way, for positive reasons. In James, what was motivating the council was to give a discount to people of pensionable age. But it is nonetheless unlawful if there is no defence of justification. And back in the head note on page 185...
Well, if it's direct discrimination, there can't be a defence of justification.
Not on sex grounds, precisely. And on 185 at the top of the page, you'll see references to where several of their lordships questioned whether it might be appropriate to have a defence of justification, even for direct discrimination. There is, of course, as we've said, such a defence in a part-time workers' context. Now, before leaving JFS, I want to make some comments about but-for causation, which again is relevant because the cases we're going to come on to, some of them make comments about but-for. In the large majority of direct discrimination cases, you could use a but-for test, as the House of Lords did in James, for example, and it would be a helpful test which would give the correct answer. That is true not only of those cases where the discrimination is inherent in the treatment, like James, but it's also true, if you think about it, of the cases where you have to think of subjective intent, because if someone's not being given a promotion because of their race, then the answer to the question, but for them being, say, black, would they have been promoted, would be yes, and it would be a helpful test to apply. However, but for is not the test, and it's not the test which is described in those paragraphs which I've just given you the references to. And I just emphasise this because the but-for test is commented on in several of these authorities with some caution. For example, Lord Phillips, in paragraph 16 of this authority, says he doesn't find it to be a helpful way of thinking about the issues. And as in other areas of law, it does have certain limits. Sometimes, but for is not a high enough test. An example of that would be, for instance, somebody who goes to, let's say, an LGBT event at work and gets into a fight and gets dismissed. Would they have been dismissed but for their sexuality and going to that event? Well, maybe no, but that doesn't prove that they were dismissed on grounds of their sexuality. That's just a contextual factor for what then happens. The kind of classic type of case where but for doesn't give you the answer. And on the other hand, sometimes but for is too high as a threshold. And the main reason for that is, when you're asking what is the reason why someone is treated in a particular way, it's not always the same question as asking what would have happened in the counterfactual world, which the but-for test requires. And there is an example that we're going to look at in a moment, which is a woman who was dismissed in part for becoming pregnant. She was a teacher at a Catholic school, a religious studies teacher at a Catholic school. She became pregnant by a priest in the local area. Yeah. And she was dismissed because of that, and the school said, well, we anyway would have dismissed her for having the relationship and so on and so forth. And that is not an answer, and that's another example where the but-for test just doesn't get you quite to the right answer. So I'm laying that on a bit thick, partly just to caution you not to go into these waters which have been discussed in other cases, and where, although but-for is often, as I say, very helpful, it's not the test. One needs to ask whether it's inherent in the conduct, inherent in the treatment, or whether it was part of the subjective motivations.
So is there a helpful verbal formula that encapsulates all of that, or not?
My lady, the best place for that is likely to be the case which Mr. Mountford is going to hand up later, which is actually only an EAT case, but there have been various... Maybe I can come back to that as well. I'll tell you why, because it was also discussed recently by Lord Justice Underhill in a case called Higgs, handed down very recently by this court, which also has a nice little encapsulation of the test, which it's right to say is a little difficult to thread together in JFS itself. And so, and I think the case Mr. Mountford was going to hand up is also an Underhill case. I may be right about that. So perhaps the two of us can speak over lunch, and I think we agree, as I understand it, on the test. So it may be that between us we can give you a neat version, maybe in Higgs, maybe in Leonard Friend's case.
I sat in Higgs, but I can't remember what was said on this point. So I'd be happy to be reminded of it.
Yes. Multiple causes. Two cases on multiple causes. The first is the case that I was just describing to you. It's called O'Neill and the Governors of St Thomas More School. It's in tab 3, page 66. the school's argument broadly was that the dismissal of Miss O'Neill was not due to pregnancy, which I just paused to mention is the same as due to sex, but was rather because of the pregnancy as a manifestation of the relationship between an RE teacher and a priest. And one can see that that other way of putting it, the relationship between them, is not necessarily directly discriminatory on grounds of sex, because this is how the school argued it. You can imagine a situation where there's a male RE teacher and a nun, was the way that they put it. So there were multiple causes, and if one goes in, it's Mr. Justice Mummery in the EAT, to page 4, internal page 43. The tribunal is here describing what they say is the correct approach to causation, referring to Banque-Roussel. And at G, the basic question is what out of the whole complex of facts before the tribunal is the effective and predominant cause or the real inefficient cause of the act complained of. As a matter of common sense, not all factors present in a situation are equally entitled to be treated as a cause of the crucial event for the purposes of attributing legal liability for consequences. But then 3, the approach to causation is further qualified by the principle that the event or factor alleged to be causative of the matter complained of need not be the only or even the main cause of the result complained of, though it must provide more than just the occasion for the result complained of. It is enough if it is an effective cause. And that is the test that I say ought to apply here, if it's an effective cause. The point is picked up again further on page 47. And I'd invite you to read that paragraph starting at B on page 47. And I, of course, underline what is said around D on that page. The same broad approach has been applied in other areas of employment law where it has been said that Parliament would have wanted to adopt essentially the same approach. In tab 11 is a case called Fessett. It's a decision from this court. The passage I'm going to point you to is over to, I should say. And it's a case about a protected disclosure, which is under the Employment Rights Act 96. The claimant had made a protected disclosure. She was moved to, he or she, I apologise, was moved to resolve what was said to be deteriorating staff relations. The question was whether that was, quotes, on the ground that they had made protected disclosure. I said it's over. That's because, as Lord Justice Elias explains at paragraphs 40 and 41 on page 290, the findings actually were that the protective disclosures played no part in the decision. But obiter at 43, it is said that the reasoning which has been adopted in other cases informed by European Union law should also be applied in this context. So unlawful discriminatory consideration should not be tolerated and ought not to have any influence on an employer's decision. My lords, what I want to turn to next is the line of authorities dealing with the issues which are before us. And that starts with the Gibson case, which is in tab 4. Page 82. And this is a decision of the EAT in Edinburgh. We're going to it because it forms the basis of the Inner House's decision in McMenemy. It concerns an ambulance driver who complained that he had to work a disproportionate number of standby hours compared to his full-time comparator. If we go, please, to page 85, you'll see at paragraph 6 the way that the arguments were pitched. The ambulance driver was saying that a but-for test should be applied and was referring to the James case, which I have mentioned as authority for that proposition. At paragraph 8, what was being said was that the but-for test was out of date, and instead one has to rely on what is said by Lord Nichols in Khan in particular, and you'll see that what is said in that paragraph is causation is a subjective test. Now, one reason why this is erroneous as a way of approaching these issues is that, as the Supreme Court in JFS makes clear, when Lord Nichols said that, he was talking about the subjective category of cases. But you'll see the way the arguments are presented here is this perceived clash between a but-for test and a subjective reason test.
There's also a reference in paragraph 10 to Mr. Napier's argument about the word solely.
That's right.
Yeah.
That's right. So there was also an argument that solely should be written in. And then at 11, you have this: in seeking to resolve this matter, we are satisfied that the proper test to be applied is as set out in Khan, albeit that is in relation to racial discrimination. Whatever may be the motive of the employer, it's necessary to look at the intention behind the decision to impose part-time working, whatever may be its consequences in other aspects. We therefore reject the but-for test in this context, and we consider that for the reasons given by the tribunal, they applied their minds to the right question and reached a conclusion, namely that the real reason was the issue of demand in the local area, which means the appellant was not being discriminated against on the ground that he was a part-time worker per se. It's also significant that on the evidence, some part-time workers in other areas did not fail to meet the pro rata principle. And it therefore, it cannot be said to be a sole question that the issue was determined by simply part-time working and nothing else.
That's slightly odd.
So it's an odd paragraph, and it proceeds, and in a sense this is no criticism of the EAT, because they'd been presented with what were presented as two conflicting House of Lords authorities. So is it but for, or is it subjective? They've resolved it by saying that they think it's not a but for test, but it's the subjective. But then wrapped up in that are some points about solely and whether one reads solely into the regulation.
So at the end, they potentially seem to be accepting. Well, I don't know about accepting, but there's an echo of Mr. Napier's submission in towards the end of the last sentence of paragraph 11.
That is right. I accept that. And calling it an echo is absolutely right. There's an echo of it.
But the reason is not at all clear, let's be honest.
And it's right to point out that they, in any event, go on to say that if they were wrong about that, then it would be justified. You see that at 16. The different treatment would be justified. The reason I underlined that latter point is that partly what's being said in 11 about the real reason being demand in the local area is that on the face of it, that is obviously relevant to justification. So you would start by saying, is there discrimination between these two individuals? And if there is, then you'd say, is it justified? And clearly, if you're running an ambulance service with very different types of demand in different areas, one can see very easily, in principle, why you may well need more people on standby, maybe working fewer hours as committed hours, but more hours on standby in particular places. So it's all obviously relevant to justification and indeed is dealt with in that way in paragraph 16. But pushing it through the lens of the reason and linking it to intention and motivation and so on, as they do in paragraph 11, is much more difficult to follow. But in any event, that's the Gibson case. And we then come to McMenemy, which is
I'm
tab
just
7.
quickly looking at the reasoning of the Employment Tribunal, which is quoted in full at paragraph 5. It's slightly more lucid than the reasoning of the EAT.
Yes, that is right, it is.
And they do take into account the fact that the word so was used. And they also say Regulation 5 uses the word the ground in the singular, which suggests the treatment should be blah blah blah.
Yes.
Yeah.
We then go to McMenemy, tab 7, so page 149. Just chronologically, just to remind you, this is still pre-JFS. And what we have in McMenemy is a call centre which was open 7 days a week, and a part-time worker who did not work on Mondays and who complained that he did not get time off in lieu when there were bank holidays on Mondays. He compared himself to a full-time worker who did work on Mondays. And just pausing there, as I've already mentioned, on those facts, my submission to the EAT was that applying the correct approach to causation, Mr. McMenemy was not a victim of direct discrimination. And here it is interesting to think of the comparison with indirect discrimination. There is no right to bring a claim for indirect discrimination on grounds of part-time status, but if there were, this would be a classic case for an indirect claim, because you can well see that a rule that people who work Mondays will either get Monday off or will get pay in lieu if there's a bank holiday is liable to disproportionately affect or have a detrimental impact on part-time workers for the simple reason that they're less likely to work on Mondays. But that's indirect. It's not a situation where the discrimination is inherent in the treatment. True it is that there's a difference between this individual and his comparator, but one has to ask whether that is because of, or in my submission partly because of, the part-time status. And the straightforward answer to that is that full-time employees might work on Mondays and part-time employees might work on Mondays. And a rule which is linked to working on Mondays does not automatically filter people depending on whether they are full-time or part-time. So on those facts, the outcome is correct. Now, I should say there's perhaps some scope for ambiguity in the way the facts are described in the case. It's not, for example, entirely clear whether he could have chosen to work on Mondays. And if he couldn't, then maybe one could get into more complicated arguments in his favour. But assuming the facts are as I've described them, there is not a case here of direct discrimination. What I take issue with is the reasoning. And on page 151, if we start with paragraph 3, you'll see that there was a discussion before us of the significance of the word solely in clause 4, and they refer to the French and German versions to reinforce what this is the straightforward reading of the English version, that solely does indeed mean the less favourable treatment, which is prohibited by the directive, must be for that reason alone. And over the page at paragraph 5, there is a reference to the paragraph that I showed you in Whipple. And I've addressed you on that. It's not entirely clear what is drawn from that, but as I apprehended, it's the words on the sole ground. As I've shown you, that wasn't what was being considered in Whipple. At 6 is the point which has already been mentioned, which is that it was not suggested the 2000 regulations went further than the directive. And then further down that, you'll see, as we've said, the prohibition is against less favourable treatment of part-time workers than comparable full-time workers for the reason that they work part-time and for that reason alone.
Well,
this
you didn't dwell on the first sentence, second sentence of 6, which might be quite significant.
My Lord, I apologise. It was not suggested the 2000 regulations went further than the directive in conferring protection on part-time workers or were intended to do more than bring UK law into line with community law. So that was the concession which was made in McMenemy, and which in several of the later cases council made clear was not made, and including in our case, I made clear at the EAT that concession was not made. So that is indeed one of the reasons why, when we come to think about Jeanne, I will say you ought not to follow or feel bound by McMenemy.
Yes, it's pretty clear from 6 what was not being argued, but it's not terribly clear what was being argued. Is it? It goes on to say where the parties disagreed was over the implications, and then they go directly to say, in our opinion, the language connotes, so they give their answer without making it clear why or what exactly the party whose argument they were rejecting, what they were saying.
My Lord, it isn't clear, and I was going to spend a bit more time on that in due course. But
sorry. Yeah.
I just mentioned paragraph 11, which summarises the submissions for the appellant. But the headline point, which I will come back to, is it's not actually clear how the sole issue was argued, or in some ways even relevant to the arguments. So I'll come back to that in a moment, if I may, but just back on paragraph 6, you get towards the end of that paragraph, as we've said, the prohibition is against less favourable treatment of part-time workers than comparable full-time workers for the reason that they work part-time and for that reason alone. So that's a sort of sole ground point. And then it says, this necessitates inquiry into the employer's intention in so treating the part-time worker. And there's not an explanation there of why it necessitates an inquiry into intention. the court quotes what was said in Gibson at paragraph 11, where they reject the but-for test. And again, keeping in mind this is all under the heading introduction rather than resolving disputes. So it necessitates inquiry into the employer's intention, and they then set out Gibson. We agree with this approach. The part-time worker who complains that his employer is treating him less favourably than he does a comparable full-time worker in breach of the legislation must therefore establish that the employer intends to treat him less favourably on the sole ground that he is a part-time worker. And then it says, additional reasons for construing the word solely in this way are that, as counsel for the response pointed out, there is first no reference in the directive to indirect discrimination, and secondly, different treatment, if established, may nevertheless be justified on objective grounds. And I'll just deal with those points very quickly, those two which are mentioned at the end of that paragraph. My headline point is it's really unclear how those points actually have any relevance to the issue. There's no reference to indirect discrimination. We're just pausing on that. That's correct. That would perhaps be a good answer to an argument that one should just proceed on a sort of but-for basis, because a but-for approach might be thought to catch something which ought to be caught by indirect discrimination. But that's simply speculation on my part, and it's not clear in this case that but-for was even argued. So it just isn't clear what the relevance is of there being no reference to indirect discrimination. And then it says, secondly, different treatment, if established, may be justified on objective grounds. And my answer to that is yes. But if that leads in any direction, it points in favour of having a more expansive approach to causation, because you can always deal with these points about motive and intention at the justification stage. I should be clear, I'm not arguing for a more expansive approach. My submission is the fact that there's justification available to the defence is just not relevant to this issue. But if one thinks about it, the only way it could, as I see it, be relevant would be to argue in favour of a more expansive approach. So that's paragraph 6. If one then goes forwards, please, to paragraph 10.
Just note, in sort of speaking up for the members of the court who decided this case, that the facts are quite interesting. On the face of it, a situation where a part-time worker who's working Wednesday, Thursday and Friday gets no benefit from the fact that most public holidays are Mondays seems very unfair. Slightly less unfair in the case of a call centre operating 7 days a week.
Yes.
Because there's evidence that his line manager at some point did work full-time Tuesday to Saturday and
yes.
got no holidays, no bank holidays at all.
Yes.
Anyway, they don't seem to have attached a great deal of importance to that.
Well, my lord, I think again, maybe in defence of the tribunal, they do attach importance to that, in the sense that the fact that the part-time worker could have worked Mondays, the full-time worker wouldn't, any full-time worker wouldn't necessarily work Mondays, is a part of their reasoning. And it's a part, I'm going to come on to it in a moment actually, they talk about hypothetical comparators, and it's part of the reasoning which I don't take any issue with, because those are interesting questions to ask on the correct approach to this issue, because they help to illuminate the question of whether the treatment is inherently discriminatory. It is right to say that in several of these cases, either the facts are difficult, or one could tweak the facts and come up with really quite difficult examples. And so in McMenemy, one can imagine, well, what if all full-time workers did work Mondays? What if part-time workers were not allowed to work Mondays? You can think of changes to the factual matrix which push you closer to inherent discrimination, certainly. But it's not there, and that's why I say that the outcome in the case is correct. I was going to go to paragraph 10
Yes.
and the judgment of the EAT. And you will see here you get a reference to the hypothetical employee. This is where they were essentially saying, well, your comparator worked Mondays, but in order to work out whether that your part-time status is the reason why you were discriminated against, we're going to think of some hypothetical employees. So that was something they were entitled to do when considering the reason why questions. It was obviously open to them to conclude that a full-time employee who did not work on Mondays would have been treated to the same as the claimant as regard Monday holidays. There was powerful evidence in support of the response case that the reason for the claimant's treatment and the ground on which he received it was nothing to do with his part-time status. And I would just underline that because the factual finding which the EAT endorses there, and which, as I understand it, the inner house doesn't take issue with, is that the treatment was nothing to do with his part-time status. So, again, when one asks why they're raising the question of sole ground, it's not clear. It's not clear because it's not clear what was being said about there being multiple grounds and how it really feeds into their analysis of the case. In 11, there is a discussion of the submissions for the appellant. And you'll see what's said is, although the appellant has stated 3 grounds of appeal, we see no need to refer to them separately. It's alleged in them that the Employment Appeal Tribunal erred in law by failing to apply a purposive approach to the legislation, that they misinterpreted the provisions relating to the pro rata principle, and they erred in law by allowing a comparison with a hypothetical employee working full-time but not Mondays. In support of these grounds, the solicitor advocate for the appellant submitted that the important point on the facts was that the working week for the appellant's team was a 5-day fixed shift. The proper comparison was between him and a full-time employee who worked Monday to Friday. The judgment of the Employment Appeal Tribunal drove a cart and horses through the purpose of the directive, as the admittedly less favourable treatment of the appellant as a part-time employee, far from being removed, was affirmed. In contradiction to the clear legislative intention, the Employment Appeal Tribunal has excluded the pro rata principle from considerations of the circumstances. Despite the existence of directly comparable full-time employees, a hypothetical full-time employee was used to defeat the principle of non-discrimination. In any event, in the circumstances of this case, where a team comprising the appellant who worked a part-time shift on Wednesdays, Thursdays and Fridays, and full-time comparator who worked a fixed shift Monday to Fridays, the only real ground for his less favourable treatment was that he was a part-time worker. So that summary of the argument, again, does not make it entirely clear how the sole ground point was feeding in to the arguments before the court. And it may be, again, as it were in deference to this very experienced court, that the submissions were not entirely clear, which might explain why they proceed by setting out their understanding of the law in some detail, before then coming to the submissions to the appellant, which they deal with very briefly in the discussion. If you go forwards to paragraph 13, and what they're really focusing on in this discussion is the hypothetical point, the hypothetical comparator, a full-time worker who didn't work on Mondays. So at 13, in fact, I'll just pause and invite my lords to read 13 and 14 to yourselves.
See in paragraph 12, counsel for respondents, who again was Mr. Napier,
Yes.
ran a very simple argument by comparison with the argument that's
Yes.
recorded earlier on in the judgment. At least that's what's recorded.
Yes. So, my lords, to be clear about this, if one looks at 14, from where halfway through that paragraph says, on examination of the facts, the reason why the appellant received less favourable treatment than did a comparable full-time worker was through the accident of his having agreed with the respondents that he would not work for them on Mondays or Tuesdays. It is at this point that it becomes legitimate to consider hypothetical situations, and so they go on. I do not fault that. That is the reason, and those hypothetical situations are useful thought experiments to test whether or not it was the reason why he was treated the way he was because of his part-time status. But the ratio in the first half of that paragraph is, in my submission, clearly wrong.
Intention.
And it mixes up intention with sole ground. So the next question is whether the less favourable treatment was solely because the appellant was a part-time worker. This, as we've discussed, requires examination of the respondent's intention. And my lords may have picked up already from the EAT judgment in this case that the EAT says, insofar as McMenemy says that it is necessary to have regard to intention, it is wrong and ought not to be followed because of JFS. But they say to the extent that it is suggesting that there can only be one cause, one sole cause, it ought to be followed and it remains binding. And that, in my submission, creates an extremely odd situation. The reasoning of this case, as I've shown you, is very tied up with intention. It's extremely difficult to disentangle those two strands, intention and sole reason. And if one does try to separate them out, it's actually very difficult to work out what the sole ground point actually was in McMenemy. I've pointed out as we went through that the EAT said that his treatment was nothing to do with his part-time status.
Well, that's a stronger finding than it wasn't the sole ground, isn't it? But it might include a finding that it wasn't the sole ground.
Yes, it's even stronger, but my point being that it wasn't, in the circumstances, it wasn't a case where the inner house had to decide what to do when there's more than one cause, one of which is discriminatory. It just doesn't appear to have been put on that basis.
Well, but the first sentence of 14 raises the issue before us fairly and squarely.
Yes.
And even if you, let's assume that Mrs. Justice Edis is right, that intention is neither here nor there. If you look at the second sentence of 14 and just cross out the two words intend to, the rest of the judgment assumes that the question is the one set out in the first sentence. The next question is whether this less favourable treatment was solely because the appellant was a part-time worker.
Yes. Well, my lord, I certainly accept one could do that. I accept that it would make sense, as it were. Linguistically, the judgment could make sense and could be followed as authority that it has to be the sole reason. And of course, as I've shown you, there are discussions in the judgment about the sole reason point, so it doesn't come from nowhere. The point that I'm making, though, is that the analysis does seem to mix up intentionality with sole ground. And if one were to ask the question, what were the facts in McMenemy which led the inner house to decide the sole ground issue? It's difficult to answer that question. Standing back, you can certainly see, in, as it were, a slightly abstract way, the employee could have been saying, but for the fact that I was part-time, I would have worked on Mondays. And so, in actual fact, there were two causes. One is that I worked part-time, and one is that I chose not to work on Mondays. He could have put together some argument like that. So it's possible that in the background there were points being made like that about multiple causes. It's not clear, though, that that was the way the argument was put to the inner house. If you look back at the appellant's arguments in paragraph 11, the focus, as I've said, is very much on the hypothetical comparator. And then there are some points which are generally about purpose of approach and so on. And it doesn't look as though there was a full-throated argument in favour of but-for causation, raising these sorts of issues. So one is left, if one adopts the approach that the EAT has said one should adopt, with, in my submission, what is an odd situation where a bit of McMenemy remains valid, but it's a bit which is really closely tied with reasoning which does not remain valid. And obviously I'm emphasising this because that is another reason why I say there are compelling reasons for this court to depart from McMenemy, quite apart from it being clearly wrong, which I do submit.
The reason there's this thread about intention goes back to the arguments that were put to the Employment Tribunal in Gibson. Because I think when you showed us Gibson, the parties were essentially saying to the Employment Tribunal, they were referring to both types of analysis, but-for and intention. And the Employment Tribunal, I suppose, thought it had to adopt one or other approach. And that then influenced McMenemy, I suppose.
Yes. Yes, and one might say, updating it to the language post-JFS, one could say, well, you do in these cases need to ask whether it's inherent, and if not, whether it's a subjective thought process. And so one could get into subjective thought process type questions. The problem is not only that it's expressed in the sort of pre-JFS language of but-for and motivation. The problem is that what the court in both Gibson and especially McMenemy say is that one has to look at intention. It's not being put forward as one limb of a two-limbed approach. What's being said is one has to look at the sole cause which necessitates inquiry into intention. From here, I can take the cases much more quickly because, of course, McMenemy is the one that we are really concerned with. And there is a comprehensive discussion of cases since McMenemy in the EAT's judgment, but I will show you the highlights, if I may. Tab 8, page 158, is the Sharma case. This is a decision of the president of the EAT. It's shortly after McMenemy, but unfortunately it appears that McMenemy was not brought to the court's attention, so they look at Gibson but not at McMenemy. It's a multiple cause case in the sense that what you had here was different categories of part-time lecturers, so they were on different contracts, and one of those categories had a contractual term permitting the employer to make a reduction in the amount of work available, and the employer took advantage of that term. And the EAT, as I have said, looks at Gibson and in very strong terms disagrees with it. Could I ask you please to turn to paragraph 47, which is on page 167. The tribunal apparently considered it was bound by Gibson to conclude the part-time nature of the worker status had to be the sole reason for the discriminatory treatment. We have no doubt that this is not a legitimate construction of the regulations. And in Gibson itself, the appeal tribunal hardly gave a ringing endorsement of the construction. My lady, that's the point which you put to me earlier on about that last sentence in paragraph 11 of Gibson being an echo. In our judgment, the reference to solely in the directive is simply intending to focus upon the fact that the discrimination against a part-timer must be because he or she is a part-timer, not for some other independent reason. To take a simple example, if the employer decided to discriminate against all part-timers over the age of 30, it could be said there were two reasons for the discrimination. Similarly, if the employer deliberately discriminates against all his part-timers in factory A, but not those in factory B, can it be said that because only some part-timers are selected for the less favourable treatment, the directive is not intended to be applicable? In our judgment, it is inconceivable that the directive was not intended to outlaw such treatment subject to justification, and we have no doubt whatsoever that it would inevitably be construed by the European Court of Justice to do so. Any other conclusion would wholly undermine the very purpose of the directive. The fact that not all part-timers are treated adversely does not mean that those who are cannot take proceedings for discrimination if being part-time is a reason for their adverse treatment. In our judgment, once it's found a part-timer is treated less favourably than a comparator, full-timer and being part-time is one of the reasons that will suffice to trigger the regulations. They go on, you'll see in paragraph 52 to say, in any event, as we indicate below, we think it's wrong to characterise the discrimination here as being for more than one reason. Properly analysed, it was only because the claimants were part-timers. I'd pause to say, when one actually reads on under the second ground, that comment that I've just read out from the end of paragraph 52 is not entirely clear. It's not entirely clear what is meant by saying it was only because they were part-timers, where, as I've described, it was because they were part-timers in a particular category. And then at 53, we would add that in any event, it's open to a member state to give more favourable protection than the directive affords. There's no need to read limitations in the directive into the regulations, and there is reference to section 19 of the Employment Relations Act. That's Sharma. The next one is the Carl case in tab 9, so starting page 171. Again, we're in the EAT, and it's Judge Peter Clark. This case concerns a part-time shorthand teacher who complained that her comparator full-time teacher was paid for preparation time, whereas she was not. The Employment Tribunal held that she could not rely on her chosen comparator, and there were several reasons for that. She was relying on a hypothetical comparator, that's not permitted under the regulations, and then the actual comparator was on analysis performing somewhat different tasks. But the tribunal went on to hold that in the alternative, any less favourable treatment was not on the sole ground that she was part-time, but because she didn't have, as I understand it, the same training as the full-time comparator. And I said just then, as I understand it, because unfortunately there is a lack of clarity in this judgment about precisely what the multiple grounds were said to be. There is a passing reference to training at paragraph 7 of the judgment, and that is why, as I understand it, what the Employment Tribunal has said was that if she was treated less favourably, it was on the grounds not only of being part-time, but also because she didn't have the same training as her full-time comparator. That is my understanding of it. In the EAT, she lost on the comparator point, which means that, unfortunately, although the EAT did consider McMenemy, everything which is said about it is obiter. Nonetheless, we do have here another case disagreeing with the reasoning in Gibson and, in this case, considering McMenemy. And could I just pick it up, please? Page 180. There is, I should say, a fairly detailed discussion from page 177. So I'm just going to the end, page 180. Where, coming to the end of this discussion, there is again a reference to that paragraph 6. It was not suggested, this is in McMenemy, it was not suggested that the 2000 regulations went further than the directive. And then it says at 41, before us, Mr. Pilgersdorfer does not make the same generous concession recorded by the Court of Session in McMenemy. He invites us to follow the President's judgment in Sharma. We're not strictly bound by any of the previous cases, even by the Court of Session. For our part, we agree with Mr. Pilgersdorfer. The expression on the ground that, or on grounds of, frequently appears in our domestic legislation. It was considered by the Court of Appeal in English in the context of the Sexual Orientation Regulations, where the majority read the domestic provisions consistently with the Equal Treatment Framework Directive, which they were designed to implement. Lord Justice Laws took a different view. However, we agree with the President in Sharma that whereas domestic legislation must provide the protection contained in the directive, it is not limited to such protection. On the ground that, in Regulation 528, means what Mummery said the similar expression in the Sex Discrimination Act meant. Part-time work must be the effective and predominant cause of the less favourable treatment complained of. It need not be the only cause. And finally, just in this line before we come to our own decision, I will show you the Forth Valley case at tab 13, page 323. Decision of Lord Fairley. It's a case about a part-time worker who complained that he didn't receive the breaks that his full-time comparator received. The short answer to that is that the reason for that difference was the length of the shifts that they were working. And true it is that if one looks from page 331, the EAT in Edinburgh in this case follows McMenemy. It was, of course, bound to do that, being in Edinburgh, and there does not appear to have been any argument to the contrary. So it is perhaps of no more than passing interest that I draw it to your attention.
Common sense does suggest that an employer who gives tasks to people who work longer hours than people who work shorter hours is not doing anything terribly wrong, but
no. It's another case where I agree on the outcome.
Yeah.
It's almost in the structure of the problem. It's almost identical to McMenemy.
Yes.
So if you ask, is it inherent in the treatment? Again, one could tweak the facts. The facts of this case were that part-time workers could actually work long shifts, and full-time workers could work short shifts if they spread them out in the right way. Tweak the facts and have a rule that part-time workers have to work short shifts. Maybe one gets a bit further on the argument of it being inherent, but on the facts of this case, the outcome is clearly correct.
Right.
It brings me to the EAT decision in our case.
Yes.
It's in the core bundle, tab 5, page 35.
Just looking at page 35, do we know if the spelling there of the name of the first lay member is correct? Mrs. Gemma Todd? Do we know whether that was her name? Is her name?
We will check.
Would you? Because I think there's another spelling somewhere else, and it might be unfortunate if we misspell it.
From paragraph 23, the EAT deals with the appeal on the grounds of less favourable treatment, which, as you know, raised a question about the application of the pro rata principle. And the appeal was upheld. I will, if I may, just take 2 minutes to explain a wrinkle which arises in the course of this, as it may help your lordships when you come to look at this. And keeping in mind, as I've said, that the way that you characterise the less favourable treatment could have some relevance to the next stage of the analysis and whether it's inherent in the treatment, whether it's discriminatory. So just picking up on this, if you look at paragraph 27, you will see in halfway down that paragraph, it is said, the claimant's complaint was not that the respondent imposed a circuit fee on all drivers, but taking his case as its most straightforward, that the imposition of a flat rate charge, which took no account of his reduced working hours, meant he was paying a higher fee than his comparator if assessed as a proportion of hours worked. And that's how I described it to your lordships earlier on today. And in the end, the tribunal proceeds on the basis that that is the way, or a way, that it can be looked at. The point I wanted to flag is it goes on to say the other way of characterising the claimant's complaint would be to see the payment of the fee in terms of his hourly take-home rate of pay as compared to that of his comparator. And that might seem like precisely the other side of the coin. The reason it's not exactly the other side of the coin is that if you look at it as his take-home rate of pay, what you will find is that there are other reasons why taxi drivers make more or less money than each other on an hourly basis, including the kinds of runs they do and the hours they work and so on and so forth. The only reason why that other way of characterising the complaint was discussed before the Employment Tribunal was that if you only apply the express words of the regulation, you have to look at pay. And so I was explaining that you could look at pay, but it takes you into rather more complex questions because you then find there are other causes for the disparities which you have to iron out when you come to giving just and equitable compensation. The EAT accepted, though, that simple way of looking at it, paying a higher fee than his comparator as a proportion of hours worked, is permissible. And in the British Airways case cited at paragraph 31, there is Court of Appeal authority for taking that sort of approach. And that is why, in the end, that, as I say, is the easiest, most straightforward way of looking at this. He paid more per hour. From paragraph 34, the EAT deals with the on the ground that issue. And what you see in 34 and 35 is the Employment Tribunal's reasoning in this case, which, in very brief, because they did consider this on the alternative, was that following McMenemy, it couldn't be said that the respondent's intention was to treat Mr. Augustine less favourably for the sole reason that he was a part-time worker. Rather, the intention was to charge him the fee so that he could obtain access to the bookings, and that was the respondent's way of running its business. So the tribunal's focus was really heavily influenced by the idea that one has to look at intention, and by bringing in at that stage matters which, in my submission, if they are relevant at all, are relevant to justification. So that was how the tribunal had approached it. And what then follows is a very detailed discussion of the authorities, which I'm not going to go through because I've gone through the authorities separately, and Essentially, the points that are made are the points which I've made to you in the course of my submissions. But I would like to pick it up, please, at page 56. Where you will see in paras 65 and 66 discussion of O'Neill and Fessett. Those are the cases which are looking at multiple causes under other discrimination legislation and the Employment Rights Act. And what the EAT says at 67 is if we were approaching Regulation 5, absent any prior judicial consideration, we would not hesitate to adopt the same approach. To require the complainant's status as a part-time worker be an effective cause of the less favourable treatment, even if not the sole cause of the treatment, seems to us to be entirely consistent both with the language of Regulation 5.2 and with the protective purpose of the legislation. To hold otherwise would seem to us to be inconsistent with the approach standardly taken to questions of causation, and to risk the obviously perverse outcomes hypothesised by President Elias at paragraph 49 of Sharma.
Just to pick up something about McMenemy, in the McMenemy decision, the court recorded that it was common ground that they ought to take a purposive approach to construing the regulation. There doesn't seem much evidence of a purposive construction in McMenemy, but here we're looking at a purposive construction by the AT. Is that right? Am I right to say that there isn't much purposive about the approach in McMenemy?
My Lord, absolutely. It's purposive, perhaps in the narrow sense that it's seen as being solely to implement the directive, but that isn't purposive as would ordinarily be understood in terms of looking at the purpose of eliminating discrimination against part-time workers. There is a discussion of the need to ensure compliance with the directive. They say at the end of 68 that wouldn't lead us to alter our approach. First, because the framework agreement is expressly stated to set out minimum requirements. And then at paragraph 70, the purposive approach, which my Lord has just mentioned, which is to provide for the removal of discrimination against part-time workers. And by reference to Sharma and the other cases that we've looked at, it is said further down that page that it would be inconsistent with the purpose of the directive if one had to show that the treatment was for one reason only, namely part-time status. So over the page at 71, the tribunal agrees with Sharma and Carl. And at 72, they recognise that they're disagreeing with Gibson, Engel, which is a case which is not in the bundle, but it's another one which simply follows McMenemy, and Forth Valley. And they say, on the assumption those decisions are not binding on us, we're unable to see any basis for inserting the word solely, or the phrase if and only if, into Regulation 5.2a. And then towards the bottom of that page, they say they consider the concession recorded at paragraph 6 of McMenemy was wrong. Para 73 is where the EAT says, for completeness, to the extent the EAT considered the respondent's intention to be relevant when determining causation, we would also consider this to demonstrate an error in its approach. That's where my learned friend's case this afternoon might come in, because there's a reference to Amnesty International, but as I see it, that simply makes the points that JFS makes several years previously and at a lower judicial level, but that's the reference to Amnesty International. And it's against that background the tribunal then comes to consider the question of precedent and decides that they ought to follow McMenemy. As you know, although we obtained permission to appeal against the treatment of precedent, that was in ignorance of the Jandruk case, and therefore that ground of appeal is not being pursued, because I accept that Jandruk would apply to the EAT, and it effectively sets the same sort of test as they themselves apply in these paragraphs. Paragraph 83. they say, for completeness, we should make clear that we thus consider we're required to read Regulation 52A as providing that the less favourable treatment must be on the sole ground that he is a part-time worker. And that's McManamy, paragraph 6. That, as we see it, is the ratio of the judgment of the inner house, notwithstanding that on the facts of the case it might have been thought that the addition of the word solely was unnecessary. The reason for the less favourable treatment was unrelated to the fact that Mr. McManamy worked part-time and purely arose from the fact that he didn't work on Mondays. All of that having been said, you'll see at 87, the EAT in part upholds the claimant's second ground of appeal. The ET erred in law because its decision on the question of causation was informed by what it found to be the respondent's intention. But then at 88, we cannot, however, agree that the claimant's appeal must therefore be upheld, asking whether the charging of a flat rate circuit fee was on the sole ground that the claimant was a part-time worker. We're unable to say that ET would have been bound to found that that was the case. And we note that Mr. Jones did not seek to put his case that high. As the ET found, the respondent's drivers worked a wide range of hours. The less favourable treatment identified by the claimant arose from failure to apply a fee that took into account the hours worked. As such, it might be said that, at least in part, the claimant was treated less favourably because he worked part-time, but the same would also be true of many of the drivers who would be characterised as working full-time. Indeed, even if the claimant had not been part-time but had worked above the average of 43.17 hours per week, which we understand to have been treated by the ET as the number of hours below which a driver would be treated as working part-time, when compared to his comparator, the imposition of the flat rate circuit fee would still have meant that he was being treated less favourably. So that's the multiple causes. And the tribunal, under the heading disposal, explains it. They gave Mr. Augustine on that basis an opportunity to ask for the matter to be remitted so that he could argue to the Employment Tribunal that essentially it was the sole ground of his treatment was his part-time status. He did not take that opportunity because, as I have explained to you, that was not the sole ground of his treatment. It was part of the reason for his less favourable treatment. They provided an opportunity to make submissions on that because this separating out of intention with sole ground was not something which had been canvassed before the AT hearing, so they raised that as a possibility. Finally, then, I should just look at the Zhuangzhuk case.
So the order that they made,
Yeah,
the one at page 31. No,
yes,
that's permission to appeal.
I think that is it.
Tab 11. Oh.
No, it is page 32.
Yes, page 32.
So in the end, they simply dismissed the appeal against the ET's rejection of the claim.
Yes, and one might want to look also in the supplementary bundle, page 9. This was the opportunity to make submissions that I mentioned a moment ago, so immediately following the hearing, or immediately following the decision. Ground 2 was partly allowed and the remainder dismissed, and there was then an opportunity to make submissions on the consequences of that. My Lords, I've dealt somewhat briefly with the EAT judgment, but I hope I've made clear the reason for that is that I almost entirely agree with it. And,
Yes.
it's an unusual situation where I don't really need to criticise the EAT's judgment. It contains a fuller description of the points than perhaps my skeleton argument does. And on the question of why McMenemy was wrong, I've made my submissions as I've gone through, and
Yes.
They are repeated in several of these authorities, so I wasn't proposing to go back over any of that. I'd, in a sense, come to the end of that and was just going to deal with the Zhuanzhuk issue, which is a short question of what is the threshold and how do I meet it. Zhuanzhuk is in tab 14 of the authorities bundle. Just for clarity, this is a case about social security statutes, and Mr. Augustine has accepted that it would apply to employment statutes, which are UK-wide as well, and that what is said about the High Court would logically apply to the EAT as well. That's a point which hasn't been subject to argument, but just for clarity, it is not a point that Mr. Augustine has taken on this appeal. So he accepts that this is the principle that needs to be followed, the approach that needs to be followed. And it is explained most crisply on page 355, paragraphs 44 and 45. Abbott and Philbin is referred to. It's a rule of practice only, and Lord Evershed acknowledged that it might be right to depart from it if there were, quotes, compelling reasons to do so. There's no discussion in the authorities of what might amount to sufficiently compelling reasons, but in my view it's clear that the bar is meant to be a high one. Although Lord Justice Ward and Dean used the language of respect, the importance of securing uniformity in the interpretation of a statute applying throughout the UK means that something more is required than the usual respect which is paid as a matter of comity to a court of coordinate jurisdiction. Nor in the light of the decision in Abbott and Philbin itself can it be enough that the second court believes that it would have decided the case the other way. In my view, the minimum requirement for a compelling reason must be that the second court believes that the first court's decision was clearly wrong, where the word clearly connotes a heightened threshold. Ms. Callaghan, supporting the Responder's notice, submitted that even that would not be sufficiently compelling. It's in truth not useful to attempt nicely to calibrate degrees of perceived wrongness, and in any event, a compelling reason for departing from the decision of the first court may depend on more than simply the strength of the second court's disagreement. In the end, the question has to be decided by reference to the circumstances of the particular case, but the important message is that it will require more than mere disagreement with the decision of the first court to justify refusal by the second court to follow it. And then at 45, because of one of the points that I rely on, it is important to read 45. A particular problem may arise where either the evidence adduced or the particular points argued before the second court are substantially different than in the first court. I can conceive that in some circumstances, at least where the differences are fundamental, that might be sufficient to justify a departure from the Abbott and Philbin rule. But generally, I believe courts should be very slow to take that course. There's a reference to Morel, where the Court of Appeal rejected the argument that the per incuriam doctrine permitted it to disregard an earlier decision of its own or of a court of coordinate jurisdiction whenever it is made to appear that the court has not, upon the earlier occasion, had the benefit of the best argument the researchers and industry of counsel could provide. The court was not in that case concerned with the decision of a court in a different UK jurisdiction, but the observation seems equally applicable. Policy reasons for maintaining a uniformity of approach between the different jurisdictions apply even if there were differences in how the two cases were presented, and resort to the Supreme Court is always available as a final arbiter. In the present case, although there are some particular arguments raised by Sheldon which may not have been raised in the same way in Northern Ireland, there is no problem about differences in the evidence. And just on that latter point, the court is not, in my submission, ruling out, as one factor among many, reliance on the proposition that here the Scottish court did not have certain points argued before it. The court's cautious about that. If that were my only point, then I might not get very far with it. But it's one of my points. And the court here, in my submission, is not saying that it's illegitimate for me to make that as one point. My points are, firstly, and there are four, firstly, that the decision in McMenemy is clearly wrong. I will not repeat the reasons for that, because it all depends how well my earlier submissions land.
Of course.
Secondly, I rely on the strong endorsement of what we may broadly call my approach by the president of the EAT in Sharma, Judge Peter Clark in Carl, and the president of the EAT in this very case. Thirdly, I rely on the fact that a concession was made in McMenemy about the scope of the regulations, which I don't make in this case. And fourthly, I rely on a point which I've already unpacked in some detail, which is what I say would be the very odd position that we would be left in if the sole ground reasoning alone in McMenemy stands, because we would not here be leaving intact a Scottish decision. It has already been in large part dismembered by JFS, and I have sought to emphasise that the point about intention appears to be closely wrapped up with what is said about sole ground. And for that fourth reason as well, I say that there are here compelling reasons to depart from McMenemy. My lords, unless I can assist further, those are my submissions.
Oh, actually, there's one tiny point that I spotted about the regulations, which I thought I'd just ask you about. I just sort of saw it as you were making submissions about the regulations. Sorry, I'm not going to waste everyone's time by trying to find the regulations in my Bible. There are one cases. I'm sorry for wasting your time like this. Yeah, sorry, it was just a tiny point on Regulation 8. Regulation 8.6, that's page 420 of the bundle. I just spotted this randomly. And this may not help one way or the other. Where a worker presents a complaint on this regulation, it's for the employer to identify the ground for the less favourable treatment or detriment. I mean, that might be a neutral provision, but I just wanted to ask you what you thought.
It's a burden of proof provision in my submission, lady.
Okay.
The directive, the burden of proof directive, wouldn't apply to part-time workers. Doesn't apply. Didn't apply. Part-time workers discrimination.
Right.
That in my submission is what that provision is concerned with. The employer needs to explain what the ground is.
Okay, that's helpful. Thank you. Thanks.
Thank you very much, Mr. Jones. We're very grateful to you. Mr. Mountford, we're all neutral on whether to hear from you for 10 minutes and then break, or break off now. Some people prefer one.
In the hands of the court, I can certainly use the 10 minutes.
Let's have a preview in 10 minutes.
My lords, my lady, what I propose to do is to address you by reference to a number of headings, 5 of those. What I want to do first of all is, in the first 4 of those, address the 4 main ways in which my learned friend has said in his skeleton argument he considers that the decision to dismiss the appeal and the decision to follow McMenemy was wrong. Those fall under the following headings. First, the question of the purpose of the directive and the framework agreement, and whether the sole causation approach is inconsistent with that purpose. Secondly, whether it is appropriate to look at other areas of discrimination law. This is what I describe as borrowings and analogy from other areas of domestic discrimination law. Thirdly, the question of whether the directive is laying down only minimum requirements and whether the regulations may and in fact have sought to go further than the directive in this case. Fourthly, the additional reasons given by McMenemy as to why the construction, emphasising the word solely in the directive, is to be preferred. And what I propose to do after those 4 is to then come back to the question of Dwanzurg and the test, and within that I want to deal with what Dwanzurg says and its treatment of Abbott and Philbin, the fact that applying that there are in fact no conflicting authorities, I say, at the moment in this area, but that were the court to appear to accede to my learned friend's invitation to depart from the enemy, that would be to create conflicting authorities.
Well, haven't we got 3 options? One is that if you're going to submit, McMenemy was rightly decided, so there's nothing to worry about. We can simply follow it.
Yes.
The second is that we think that McMenemy on the whole was wrong, but the compelling reason, or say craziness, test which Lord Justice Underhill lays down in Wanchuk is not satisfied, and we should therefore dismiss the appeal, even though we don't agree with McMenemy. Consider query whether there should be permission to appeal to the Supreme Court.
Yes.
Thirdly, is that we do consider that the high bar set in Wanchuk is satisfied, in which case we would allow the appeal and refuse to follow it. Those are the 3 options, aren't they?
Those are the 3 options, Martin. What my submission is addressed to is that if the court was to go down the 3rd of those approaches, then looking at the various authorities that have been canvassed, McMenemy, Gibson, the AT's decision below, Sharma, that would be to create a fissure at the level of the EAT as to the appropriate way to interpret this language, because in England and Wales, and for appeals from England and Welsh employment tribunals, they and the Employment Appeals Tribunal would be bound to apply this court's judgment, whereas in employment tribunals in Scotland and in the EAT, when hearing appeals from Scottish employment tribunals, they would still remain bound by McMenemy.
Yes.
So that's bound up with what I say, because there was a suggestion in the case, in the decision below, there's reference to conflicting decisions, and while I accept that there was conflicting reasoning, what I say is that actually at the moment, from the perspective of somebody trying to work out what the law is, or the employment tribunal is trying to apply that, it is clear in light of the decision below that McMenemy currently sets out the correct position.
Because it's the inner house. Not, yeah.
Yes. So then my the final limb of my 5th topic of Dwanzurg is to come back and address the test of compelling reasons. First of all, I will say, as I will try to show under the first 4 of my headings, that the McMenemy decision is not wrong. It's certainly not clearly wrong.
Mm-hmm.
But even if it were, in your lordship's, my lady's view, clearly wrong, I would say that is not sufficient in these circumstances to amount to compelling reasons, because of the extreme extremely unfortunate consequences for precedent and for the operation of a GB, an interpretation of a GB-wide statute, to have that fissure at the level of the EAT as to the interpretation of the same statutory provision applying throughout England, Wales and Scotland. So that's my route map.
Good. Well, that's the route map. There's probably no point having 5 minutes on point one. Is that let's break off now and resume at 1:55.